All rise. Please be seated. We are to our second case of the morning. That case is case number 2022-2318. Dorian Roberts individually and as trustee of the Dorian Roberts Trust versus Florida Insurance Guarantee, and I am wrong about that. I apologize. It said 10 o'clock. I'm sorry. Let me start again. We're on the second case of the day, the second 9 o'clock case of the day. That is Medfast Urgent Care Centers, LLC versus Logan Arbogast. Case number 2024-2576. Wanted to shake you guys up a little bit.
That worked.
I had a no way, like I'm here on the wrong case. So I apologize. Counsel, Mr. Volt?
Yes, Your Honor.
Please come forward. And how much time would you like to reserve for rebuttal?
Rebuttal of 5 minutes would be fine. I'd like 5 hours because the record's so extensive, but 5 minutes will be fine.
Yes, sir. And why don't you start by just telling us very briefly what this case is about? And Ms. Peoples did that in the last OA, but just maybe a brief synopsis about what we're here for.
The easiest way to look at this case is that this is a case of unfair competition. In America, competition is good, unfair competition is bad. We're talking about concepts of loyalty, honesty, fiduciary duty of an employee and someone who came in to shadow an employee, learned how to conduct themselves in operating an urgent care clinic for about a year and a half in the case of Mr. Arbogast, and then was shadowed by Mr. Torpy for a shorter period of time. Mr. Torpy falsely represented that he wanted to go to physician assistant school and he needed a certain amount of hours to apply. He never applied to physician assistant school.
And to understand, just for everyone's benefit, we're hearing a motion to amend that was denied.
Thank you, Your Honor.
And the reason is because in Florida, you're not allowed to plead punitives in an initial complaint, except in very rare circumstances, not in cases like this one. And so there was a motion to amend to add a claim for punitives that was denied, correct?
That's right, Your Honor.
And I'll start off the questioning. The judge gets that case. How does the judge evaluate whether or not to allow an amendment to the complaint to include a claim for punitive damages? How does that happen?
Florida statute 768.72 governs the amendment of pleadings. It is a pleading issue. Can you have leave to amend to raise a claim for punitive damages in certain types of claims where punitive damages are recoverable? And here we have a breach of fiduciary duty, we have a civil conspiracy, we have an interference of contract, and we have 2 fraud claims. These are all intentional wrongdoing business torts.
I'm going to try to drill down a little bit more, Mr. Volk, if I may, because I think this is important, and I don't know that there's a case out there definitively saying how this happens, but a circuit judge is sitting there. What is their evaluation? Are they looking at evidence? Are they looking at pleadings? Are they looking at proffers? Are they looking at both? Is there testimony taken? How does this happen?
Excellent question, Your Honor. It's not a question of a trial. It is not a question of a summary judgment proceeding. The statute provides for the submission of evidence in support of the amendment of the pleading or evidence, either or. And the case law in the 5th DCA and elsewhere defines what proffer is. It is a representation of what evidence may be presented. And so you don't have to put on a trial, you don't have to call witnesses. In this case, for instance, we did both. We filed the proposed second amended complaint, which is included as part of our proffer. And it set forth what the trial judge found to be worthy of amendment to allow fraud claims against Arbogast and Torpy.
As to the pleading itself.
Correct.
And so, but on this proffer side, so then you proffer evidence. can the other side come in and say, no, that's not the evidence here. I've got some evidence too that needs to be considered by the circuit judge.
I don't think so. And I don't think that's the standard.
And why is that?
Because of statutory construction. If we look at the wording of the statute, it says proffer or evidence offered by the claimant. Evidence in the record or proffered by the claimant. And so I think by the plain wording of the statute, we don't have the battle of the evidence at this stage of the proceedings. That's what we have trials for. That's what we have motions for summary.
Just so I understand the argument, Mr. Volk, and I'm looking at the statute, and that is, for the record, Section 768.7.2, evidence in the record or proffered by the claimant.
Yes.
And you're saying that means the proffer is the claimant's proffer, not the defense proffer.
Correct.
What about evidence in the record? And suppose the other side said, I'm going to file a bunch of evidence in the record to give our side of the story.
I think it's a bursting bubble. If we put forth a case, and believe it or not, we had a summary judgment ruling here where the judge said, I think you've proved your case through summary judgment, but now I look to the evidence presented by the other side and find that there are some factual issues, so we must go to trial. But I believe 768.72 is bursting bubble. Once we make our showing, we amend the pleading. And then they get to answer the pleading.
One more question from this judge, and others may have more questions, Mr. Vogt, but where is that case telling us this is the algorithm for the trial judge? I know Copeland sort of talks about it, 2017, Judge Edwards, but it just talks about the court being a gatekeeper. I don't know, is there a case that takes us through the steps of what a circuit judge needs to do in these cases?
I think so.
In which case is that?
I think the Fifth Circuit has been very helpful. In these cases in particular, we're bound by Fifth Circuit.
You mean the Fifth District?
Fifth District.
Yes, sir.
Yes. Fifth Circuit.
That would be a lifetime appointment.
I have one of those in my family, brother. Cook versus Florida Peninsula Insurance Company is a Florida 5th DCA case, 2023, and it looks at the reasonableness and sufficiency of the proffer. The trial court was, and this court is required, to view the proffer and the record in favor of Medfest, to take the proffered facts as true, and to construe all inferences of these facts in favor of Medfest. And there's other cases that support that proposition. So I think it's a pleading issue, a pleading standard issue. Can you burst that bubble? If you amend the pleading, have you put forth all the elements of the claim and adequate supporting facts to support it?
Is the appellee in this case permitted to argue the absence of evidence or the lack of evidence when you're arguing that you have presented a reasonable basis for punitive damages?
I suppose it sounds like an extreme position, but no, I don't think they get to do that. They can
So
argue against my
They
argument.
have to sit there quiet and just accept whatever you proffer as 100% true and accurate so that you rise to the level. We're talking here basically the level of reckless conduct, right? And in some courts it's been described as a level of conduct that is equal to criminal manslaughter, correct?
I don't buy that, frankly. And again, the burden is on the
Well,
claimant.
that's not me saying that. That was said long before I became an appellate court judge in cases on more than one occasion. So you may not buy it, but we're bound by those cases to the extent they are within or in our jurisdiction, correct?
Understandable. If it's in our jurisdiction, it's binding. And so we have Cook, we have Werner, we have Fish that talks about these types of activities.
And I was part of the Werner panel, as was Judge South. We didn't really talk about, we talked about generally the standard, but we didn't talk about the specifics of the mechanism of how a circuit judge goes about making this analysis. And that seems to me to be a very important issue. And back to Judge Wallace's question, so the defense attorney just stands silent, sits silent in the midst of all this? They have no ability to say anything from an evidentiary standpoint?
That's my reading of the statute, and that's all we're guided by. What does the statute say? We can't dial in additional procedures changing the statute. The statute doesn't say that the opponent is allowed to come forward with evidence.
Mr. Volk, in your case, were there any facts or evidence presented to this trial court that the appellee, at the time they signed the employment agreement, had already hatched a plan or was beginning to construct a competitor's business or the intention to go forward and work for a competitor at the time that they signed that employment agreement with your client?
Yes, Judge Wallace, and as you know, the intention to not perform a contract is fraud in the inducement. And in this case, we have Mr. Arbogast testifying under oath. I got legal counsel. I didn't want to sign this. He went to the office manager, now the CEO of the company, and said, I don't want to sign this non-compete, non-solicitation, confidential information agreement. Can you take stuff out of it? And Amy Whitlock said, no, everyone who works here has to sign this. I found out when I deposed him, he had no intention of abiding his promises. After all an agreement is promises. And so he knew in his heart that he didn't think he was bound. He even got lawyers to tell him, you're not bound,
but that's
is troubling.
That's not my question. My question was there any evidence that he intended and had already taken affirmative steps to create a competing business with your client at the time he signed that agreement? That was my question.
No. But a trial was not confined to one tiny space. And the court did allow me to amend the pleading to raise the fraud claim against Mr. Arbogast and against Mr. Torpy, saying that I had adequately pleaded the heightened standard required for fraud claims.
Is that in the analysis? I mean, the pleading, whether or not it's adequately pleaded, that's just the first issue, is it not?
Well, sure, but I consider the amended pleading and the motion to amend as part of our proffer.
No, I understand. Okay, you consider it as part of your proffer, but part of the court's analysis is whether or not, and I believe it's born of the statute, and I applaud and welcome any discussion as to the text of a statute and how it guides us. There's another requirement as to whether or not it's been demonstrated that there's a reasonable basis by which a reasonable jury could award punitives. And that requires some analysis by the gatekeeper, the trial judge, to determine if there's not just a pleading component, but an evidentiary component for the award of punitive damages to allow the claim to go forward, to subject the opposing party to financial discovery and the like, right?
Yes, and I consider that part of the proffer in the proposed amended complaint and the motion to amend. And the court found you've adequately raised facts and the legal elements to show fraud. And
do you extend your argument to the point of a claimant proffers evidence by way of a deposition transcript, and a defendant is not entitled to highlight testimony within that deposition that may further expound or shed light on portions of the deposition the plaintiff is relied upon in seeking to amend punitive? That we just that the defendant is required to sit there, as Judge Wallace, I think, in utter silence.
You get into the chaotic problem we had here where you're looking at competing proof and weighing evidence. And Judge Blau weighed evidence. And we addressed that in the brief. If you read his ruling, he said, I've had experience with cases like this. I've considered proof from both sides. I've essentially weighed the evidence. But the horrible problem is that he only focused on this much of the case. And for purpose of the record, I'm holding my fingers about a 1/4 inch apart. And the case is this big, which is about 3 feet apart.
So basically what you're saying is context is irrelevant. It's
because at that point you're weighing. But if I get a direct statement in a deposition, do you get to try and water it down through other evidence? Again, it's a question, reasonable jury. Reasonable jury. And the judge just saying, I think you brought me enough. And bear in mind, Your Honor, there are still procedural safeguards. You do massive harm to the plaintiff if you deny this appeal.
Well, but the procedural safeguards are only after you have been able to open up a pretty vast area of discovery because you have a claim for punitive damages. You agree? Otherwise, it's not available to you to discover a lot of financial, a lot of business operation evidence that ordinarily wouldn't be relevant, but now because you have a punitive damage claim, that's wide open and Katie barred the door.
It's still subject to discovery boundaries. Reasonable could lead to relevant evidence.
Well, that's certainly true, but has not the Fifth District said that a defendant has a substantive right not to be subjected to financial discovery absent satisfying the statute?
Sure.
So there's a substantive right at issue, is there not?
I think so.
So I wanted to ask and follow up. I know there's been a lot of questions by folks that are much smarter than me, but I wanted to follow up since we're focusing on the language of the statute, and it was asked earlier, I believe you may have raised earlier, that one of the appellees may have sought legal counsel as it pertains to the non-compete agreement. Gross negligence is not an issue, right? This is intentional. I think you said that earlier.
Well, I disagree. The statute provides for gross negligence, which is a willful indifference to the rights of others.
Okay, so you believe...
Willful or reckless, both. And obviously, the gross negligence statute as defined, the gross negligence definition as defined in the statute is much easier to achieve.
Okay.
Because there's no question here, these guys have a conscious indifference to the rights of who they learned how to operate an urgent care clinic from. And going to the record, you see, neither of them had any experience in this. You go to the record, you read all those transcripts, you see Arbogast sending Medfast documents to Torpy. You see, before Mr. Arbogast even resigns, that they've formed the business entity, that they've got a website up and running, which is, as we know, competition these days because it creates confusion. Urgent care is near me. When you do your Google search, you're going to see a competitor. They make much of the fact that they didn't open for a while because they did their build out without a permit. It slowed them down. They quit paying their rent, on and on, which is not really germane to today. But they were up and running before Mr. Arbogast even resigned. And if that's not evidence of intent, that ties in. You go back to that initial intent to not perform. I'm not bound by this. And yet, I will sign a document where I promise I'm bound. And isn't that deceit?
Well, I think what Judge Soud was getting at, and I don't want to put words into his mouth, but he referenced the fact that he saw an attorney. So you're making the argument that just the mere fact that the appellee sought advice from an attorney was in some way, shape, or form evidence which would justify amending your complaint to add a claim for punitive damage?
Well, as to the fraud claim, now bear in mind we've got numerous tort claims here. And Judge Blau, I think, only looked at the fraud issue and only looked at Arbogast's fraud at the outset based on he saw a lawyer. But this proves when he signed that agreement, he did not believe he had to honor it. And that's dishonest.
Well, and whether it's dishonest, that's certainly one question. But the statute in defining intentional misconduct, and I appreciate your clarification that you may proceed under both intentional and gross negligence if allowed to proceed under punitive damages, but the statute 768.722A defines intentional misconduct as the defendant had, and I'm quoting, actual knowledge of the wrongfulness of the conduct. And my question is, if that's the statutory language and he signs an agreement and a lawyer has previously told him that the non-compete as drafted is overbroad and therefore unenforceable, is that relevant to the trial court's consideration as to whether or not Arbogast had actual knowledge, of the wrongfulness, legal wrongfulness of his conduct?
Excellent question. It proves it. Because he formed that intent to not be bound, but he signed a document saying he would be bound. It helps us more than it hurts us.
But is it relevant that he had legal advice that he is not legally bound?
No, because he's still making the false statement when he signs the agreement. He's saying, yeah, I'll sign this. I don't care what it says. I'm not abiding it. I don't have to abide it. Without telling the party that he signs the agreement with, hey, this isn't legally binding. Why didn't he do that? hey, this isn't legally binding. Hey, can my lawyer negotiate with your lawyer? He keeps it a secret. I didn't find that out until I deposed him. My client obviously did not find that out until I deposed him and got the admission. Why'd you sign it?
Mr. Vogt, you're well into your rebuttal time, but we have asked you questions during that rebuttal time, so I'm going to give you 2 more minutes. That'll give you about 3.5 minutes for rebuttal. I'll also give Mr. Marks, if he feels so inclined, 2 additional minutes. So unless there's anything further.
Just one final point. Again, this is a pleading issue.
In your rebuttal time.
I know that.
Go ahead.
This is a pleading issue, not a winning the case issue. There are still events to happen, and we've been embarking on a horrendous effort to get discovery from the defendants, including an order where the judge just recently said we've been prejudiced. And the reason that can be relevant for today is in our motion to amend, I cite to a Middle District of Florida case, obviously not binding, saying proffer's okay because you're going to continue to flesh out the case as you go along through discovery. Thank you.
Thank you. Mr. Marks?
Yes, sir. Please support Douglas Marks on behalf of the defendants. I'd like, excuse me, I'd like to address Judge Jay's initial question first in terms of how this comes about in the methodology of the trial court.
Please help us out. Help out the trial judges of the state of
We
Florida.
start with a proffer. And if the court will allow me, I'll come back to what that proffer is in a minute. But the court would then evaluate that proffer and play it against or consider it against the statutory requirement for punitive damages, which the case law clearly says is the most egregious and outrageous conduct, such that it warrants punishment as opposed to compensation. Now, in terms of the proffer, where a plaintiff proffers a deposition, the concept that the defendants have no opportunity to say, that's not what it says, that's taken out of context, that's plain wrong, I don't believe is the law under any of the varying cases that deal with the methodology. And
Where would you find that mechanism in the statute? And it might be a reasonable showing. So it has to be reasonable, and you would say that there would be a right to question the proffer, because not questioning the proffer would suggest it could be unreasonable. And so you would have the right to question it to make sure it's reasonable. But I don't want to put words in your mouth. That seems to be what the statute says.
I think the proffer, and they talk about record evidence, so that the concept of what the statute is saying is you can proffer record evidence, but I can't, is unreasonable. But I think something that's very important in this particular case is...
Well, I'm not suggesting it is unreasonable, but we bow our knee to what the statute says. And to the extent it may be, that's something to take up in Tallahassee. But you're saying in the statute itself is this right, you believe, would be for the defendant to also be able to talk about evidence and to put in evidence? Are you saying put in evidence?
I'm saying that the defendants should be allowed to proffer evidence from the same source, in this case deposition, that the plaintiff has proffered. But I think what's important in this case is the depositions were their proffer. They proffered, and they admitted in page 18 of their brief, they proffered the entire transcript of the depositions of Arbogast, of Torpy, and a witness named Spicer.
So you're saying they put in the whole transcript, so all of it's fair game?
This was not a question where they came in and said, page 24, line 14, he admitted he was drunk when he was driving. They proffered the entire deposition and now come before this court and came before the trial court and said, you can't refer to anything else. Well, what the court did was evaluate the proffer in its totality. And the concept that I can proffer an entire deposition, select portions of the deposition to cite to the court, because the proffer is broader than the cite. And then I can say, Judge, you can't consider the same deposition that I just proffered in other areas. The statute doesn't say that, and I don't think that the statute really lays out the methodology for conducting one of these hearings.
You understand, I'm sure, Mr. Marks, we have circuit judges all over the state that deal with this, if not daily, weekly, and certainly monthly. And the question if I was sitting in that seat, I would say, well, help me out here. Does the defense get to present evidence? Does the defense is the defense allowed to poke holes in this? Is the defense allowed to show other things out of completeness? Those things seem to me, again, this judge, as guardrails that maybe we need to provide based on what judges are going about every day. So what you would say is, in our case, we're here about today, full deposition, that's fair game. But what about if Mr. Volk had only taken, and you said that's what he did anyway, but let's say he only took parts of the deposition and proffered those. Would you have the right to show the rest of the deposition to the judge?
I believe the substantive right to be free from punitive damages until a court makes a determination that the standard has been met is of little comfort to a defendant who essentially doesn't get to defend himself at the hearing and say, I didn't say that in my deposition. Look at this. We're not talking about a proffer by the defense in this case that went outside of what had been proffered by the plaintiff in terms of the entire transcript. I think there is confusion throughout the state as to what this process is, and we've pointed out in our brief, the differing approaches that district courts have taken.
So on behalf of your clients, what approach should this court take?
I believe this court should take the approach that the defendant should be entitled to proffer in opposition to what the plaintiff proffered. But the court in this particular case, I would submit, doesn't have to go that far, because what we are saying is you proffered an entire deposition. You said, here's our support, the entire deposition. And clearly, without going further than this court has in the past, this court should be able to say, well, you can't defeat a substantive right, as Judge Stout alluded to, by saying you can't even address what's in the same deposition that I proffered, which is the position that you're taking. Now, the concept, just to leave the methodology question for a minute, the concept that I can be in negotiation for an agreement, I ask that a particular portion of the agreement be removed, and that 17 months later.
Well, what about his argument in response to Judge Stout's question? He sort of turned the argument back on you and said, well, this makes it even more insidious because he had legal advice saying this doesn't work. This is not enforceable. This is perhaps illegal. But he signed it anyway, which makes it more intentional. That's the way I heard Mr. Volk say it. Why is that not true?
Because people in the negotiation of a contract sign agreements every day with provisions that they don't like, that they couldn't negotiate out of the agreement, and they sign them. To contend that the act of signing the agreement, believing that the non-compete was unenforceable, demonstrates the intent at that moment to not honor the agreement in the future is not supported by any evidence in this record.
Well, what about, but this devil's advocate, signing it at that moment, knowing, according to his testimony, that it was not enforceable, isn't that intentionally signing something that you know you're not going to be bound by?
I don't believe so. In that 17 months, a number of things could happen. He could move. He could practice outside the provisions of the non-compete. The question on that claim is doing that at that moment, trying to negotiate the provision out unsuccessfully, does that create an intentional act of wrongdoing sufficient to meet a standard for punitive damages? And I'd suggest it's not even close.
You mentioned outrageous. I wrote it down, and I'm familiar with those cases, including a case from our court. I don't see outrageous in the statute, and I traced it last night. Went to the 4th DCA, went to the 2nd DCA. I don't see a Supreme Court case saying outrageous, but it almost sounds like we have duped in the McCarson standard, intentional infliction of emotional distress, into the punitive damages realm. So first, that's a long way lead into my question. Where is that in the statute, outrageous? And two, is there a Supreme Court case saying the standard is outrageous?
I don't believe so. I haven't seen one. And
Doesn't it sound like the IIED standard, Mr. Marks?
I think that's why you see the proliferation of opinions as to how to administer this statute that we alluded to in our brief. But you go back to the language of intentional misconduct, and the courts have said you have to have the specific intent to engage in wrongful conduct. I think that's where that analysis flows from the definition of intentional misconduct in the statute.
Mr. Marks, how about this hypothetical? Okay. So I take one of my children to an athletic venue where they're to participate in some sort of athletic event. They present me with a waiver document, a waiver form that tells me by signing this document, it's the only way my child will be able to participate in this event. And by signing this document, I am waiving any right, if there's an injury, to pursue that injury in a court within the state of Florida. I'm going to have to go through arbitration or another process. I'm not a lawyer, or I don't understand this. So I pick up the phone, I call my lawyer, and I ask my lawyer, this is the document I have been presented with. Am I going to be bound by that if I sign this document? And my lawyer says, no, it's boilerplate, there's no quid pro quo, there's no consideration. Even if you sign it, it's not enforceable. I sign that document. Have I committed fraud?
I don't believe you've committed fraud because there's a difference between committing fraud and the effectiveness of the release. So I don't believe that you would be committing fraud, nor would there be a plaintiff who suffered damages as a result of the claim of fraud in signing the release. Here we have a situation where, can you imagine the plethora of lawsuits that would follow every time you unsuccessfully negotiated a contract on a particular point in the contract? And some 17 months or 2 years later, there was a claim that you breached the contract. And that if you could go back and say, see, the breach means you didn't mean to abide by what you tried to negotiate out of the contract in the first place, that would be a radical expansion of the concept of fraud and inducement, in my view.
And another question, what evidence is missing from the appellant's case in this case that you believe if that evidence would have been present, it would have been sufficient to satisfy a reasonable basis to amend the claim to add a claim for punitive damage?
Evidence that would take it out of the, kind of the norm for what is claimed in a non-compete case. I think a good example is your Mercer case. We addressed it in our brief, what happened in that case.
Do you mean Werner?
Werner, I'm sorry.
Yes, go ahead.
You addressed it in that case, and you look at that case, and that's pretty bad. But here you have a proffer of things that, some of them aren't even actionable. Like Mr. Vogt says, well, you learn the business. We've cited cases in our brief. That's not actionable. An employee is entitled to take what he learned in one business and apply that in his work in another business. And you cited that in the brief. Things that you do in preparation to form a new business and to compete are not actionable. It's the Fish versus Adams case from this court a long time ago, and we cited another case. They have things in there about, Torpy, he went to law school and he become a lawyer and a whole host of things that don't add up. And then we have conclusory allegations. They say, well, Arbogast got specialized training, and they parrot the language of the statute without describing the training that he received. They said that you appropriated confidential information without once defining what that is or explaining what document you're talking about. They said that the one I was going to talk about escapes me at the moment, but these things are in many cases not even actionable, let alone meet the standard of intentional misconduct in the statute. So I hope I answered your question. Thank you.
Mr. Vogt, 2 minutes and 38 seconds. You may proceed.
Thank you, Your Honor. Again, we're limited by the statute and the language, and it defines intentional and it defines gross negligence, which is a pretty low burden. Werner cites the statute, I believe it says intentional misconduct happens when a defendant has actual knowledge of the wrongfulness of the conduct and the high probability that it will harm the plaintiff, but nevertheless intentionally pursues that course of conduct resulting in said harm.
What do you do
burden to get over?
Ms. Volk, and I'll give you a few extra seconds if I run through your rebuttal time, but Judge Wallace asked a good question about our hands are tied as to this manslaughter standard because that emanates from a Florida Supreme Court case, and that was an interpretation of gross negligence. So I mean, you may not like it, but that's what the Florida Supreme Court has told us gross negligence means, that you got to have something really bad. I mean, it's not just simple negligence. It's so reckless or wanting, it constitutes a conscious disregard that would get us into potentially a manslaughter standard.
Can the Supreme Court change the language of a statute to change the definition of gross negligence?
You're right, Mr. Vogt, and they can't, but we're bound by what they did, and there's nothing we can do about that. Now, you could ask the Supreme Court to change their mind about the interpretation of the statute, but sitting here today, that is our court that we answer to.
Words have different meanings in different contexts. Phrases have different meanings in different contexts. Words can sound alike and have different meanings. Again, was the Supreme Court construing 768.72 in a manslaughter case? No, of course not. And throughout our code, or Florida code, we have different definitions for different terms. So if the Florida Supreme Court construes a criminal statute, that wouldn't affect a commercial law case under 768.72. I don't think you're bound by them construing something else for a term.
Well, the case he was talking about was a punitive damages case.
In a criminal case?
No.
Manslaughter case?
No, sir. It was a civil case. I read it. Read a lot of cases last night, but I read it as I was doing a jet tour through the cases. The very words he used were used by the Supreme Court of Florida. So, like it or not, it seems to me that's game, set, match as far as the standard. But go ahead. I'll let you sum up your argument, Mr. Vogt.
If you read the entire transcripts of Arbogast, Torpy, Spicer, you see that there was this wrongful conduct, at least reckless indifference. In the fall of 2021, they're hatching their scheme. Before Arbogast resigns, They've set up the company and the website. They weren't just competing or planning on competing. They were taking actions that were violating Mr. Arbogast's fiduciary duties to his employer. That was disloyal, okay? And to make matters even worse, he resigns December 27.
Thank you, Mr. Vogt, and we're through all your time. It was well presented.